Well, those were the decisions that transpired yesterday. Well, Mr. Okezie-Okafor, a senior advocate of Nigeria, joins us this morning to give his perspective on this matter. Morning, and thank you for joining us. Well, first and foremost, there were those who, laymen who were just watching as this scenario unfolds, particularly as it has to do with River State. They ask, so how could the tribunal and the Court of Appeal give two judgments with which, and then the Supreme Court completely throws those judgments out and then gives a different, and this is a unanimous decision. So when people say something is wrong with the judiciary, are they right or wrong to be of that impression?
Hello?
Yes, go ahead, please.
Yes, the Supreme Court has restored hope, to lawyers in Nigeria, because the judgments came at a time when we felt that we are consolidating against in democracy. Yes, and then, law should be certain. And when law is no longer certain, then there's no confidence in the judicial process. And that is why it is said that one of the characteristics of law is that it must have to be certain. So we know that before now we are talking about we don't have character, but then we also have an electoral act that had not been amended. And looking at the decisions already of the Supreme Court in respect of the electoral act. Therefore, if you go to those decisions, you see that there's no way you can prove overvoting without bringing a voters register. So the mere fact that the guidelines and manuals of the INEC are not carried out has not changed the position of the law. The law still is the electoral act and not manual or guidelines. So when the Court of Appeal went on to nullify elections based on manual and guidelines, they were not acting in accordance with the law, and then they were not making the law to be certain. So that's my view about it, that the judgment of Supreme Court in all these matters we had yesterday restored the hope of Nigerian people, particularly lawyers in the judiciary.
But yes, the Supreme Court, that's the final decision, and as you say, you have to appeal to God if they're not happy with the decision of the Supreme Court. But then some of the key questions also, how do people ensure that this kinds of judgment that was delivered in the tribunal and the appeal, it raises a lot of questions about how confidence in the judiciary needs to be really strong. Do you think from this judgment now that, who knows, subsequently, this is a precedent that has been set now, and there should be no reason whatsoever to give such perhaps erroneous judgment as Supreme Court has proved it to be now?
Yeah, these judgments constitute precedents. But before then, there are judgments that have been delivered by the Supreme Court that should have guided the matter. And these good judgments have been looked into and applied. Both the tribunal and the Court of Appeal will not have arrived at that decision which they did that have not been nullified by the Supreme Court.
But how could both courts, how could the tribunal and the appeal overlook those precedents to then arrive at their own judgment, which is what many don't understand?
Sorry, I didn't get you well.
How did those two courts, the two cases, the tribunal and the appeal, overlook the precedents to arrive at their decision?
No, that is what they're saying, that something is wrong. Something is wrong in the sense that since there are other judicial pronouncements made earlier, even before now, that you have guided the transaction, which were not applied, it means that something was wrong somewhere. And then you can also see that the judgments of the Court of Appeal were conflicting. So something is wrong.
The statement by the CJN the other day that Court of Appeal, they just need to ensure they give consistent judgment. Does this speak to this particular issue?
Sorry, what are the issues?
The CJN the other day speaking about Court of Appeals giving inconsistent judgments. Do you think this in any way references that statement of his?
Yes, the CJN is a man of candor and integrity. And it serves us well for him to own up that there has been conflicting judgments of the Court of Appeal. And that means he's transparent and honest. And does not want that kind of system to be perpetuated. This conflicting judgments means that nobody is sure what is the position of the law.
Okay, now I was just going to ask, about the appeal court judgment now. Looking at where it is that the manner in which the Supreme Court has given its judgment is yet to give its reasons. Can we fully say that we understand the reason why the Supreme Court, arrived at the judgment that it arrived at?
Yes, because of the time frame, the Supreme Court must hear this matter within 60 days from the date of the judgment of the Court of Appeal. And there are so many cases now in the Supreme Court. So as the first court, they have no choice than to give their judgment within 60 days, considering provided for, and then give their reasons later. And why it is so is that there is no further appeal after the decision of the Supreme Court. So the reasons can come later. And for us as lawyers, we all know the reasons. We all know already why the Supreme Court took the stand they took. I happen to be one of the lawyers. In fact, I appeared in Mahi's case. I'm the counsel for Mahi, the governor of Okezie State. Mm-hmm. So I know the reasons why the judgment went in our favor, even without seeing the full text of the judgment.
Can you share with us, because for some who can't wait till February 12th to get to all of their reasons, it's good that you're talking to us now. Tell us some of the reasons the judgment went in your favor.
Yes, basically the issue there which surpasses all the other issues, all the matters, both in the Wike and the Muslim. One issue there is the issue of probative value that should be attached to INEC sacrifice result sheets, which were tendered to prove overvoted without calling oral evidence of those who have knowledge of the contents of the document. So some of the current decisions will not tell you that those results could be looked into and then used to determine the matter. When those people who knew the truth about the contents of the document were not called to give evidence. So the evidence became hearsay evidence. So it was not for the Court of Appeal to have acted on those documents without those people who know or have knowledge of the content testifying in the matter. And secondly, this issue of carrier report. Before now, the Supreme Court of Appeal at Lagos had given judgment that the carrier is not a progenitor of the Electoral Act and should not constitute a ground for nullifying an election. So Supreme Court affirmed it and said, no, you cannot use carrier to nullify an election. It's a mere direction by the Commission and not a breach. It's not a breach of the Electoral Act. So these are some of the matters that we're looking to by the Supreme Court.
Considering how contentious the card reader was, I mean, we've seen it at all levels of the tribunal, eventually until we got to the Supreme Court. Considering how contentious it was, what would be your recommendation to INEC on the use of the card reader?
Well, what will happen, which we all are advocating for, is that there should be an amendment of the Extant Electoral Act. So the card reader will be incorporated into the Electoral Act. Until it is done, what we know it should be the use of voters register, as has been pronounced upon in Buhari, by Supreme Court in Buhari versus Obasanjo.
You don't think that it should be done away with?
No. I'm saying that if we want to continue with the corridor, what we have to do is to amend the Electoral Act, to incorporate it into the Electoral Act. Until it is done, it's not a law.
So are you saying then, sorry to interrupt you, Chimele, are you saying then that it is possible that, you know, the elections might not have been fair, as it were? I'm just asking, it's just a question, I mean, but because it's not supported by law, you know, there is no way that the Supreme Court would have upheld that particular, or the evidence of the card reader, as it were?
I have to say two things on this. One is that justice must be according to law. Justice is not according to common sense or mere fairness. Justice must be according to law, so that there should be a standard. And that's why we're talking about certainty of the law. Secondly, is that even Karga failed in many places. So it has to be straightened up. And once it is straightened up, then the electoral act will not be amended to incorporate it.
You know, there are those who say that this happened, I mean, the judgments were given because they had the opportunity to get to the Supreme Court. But in those cases where their own final court of instance is the Court of Appeal, what do you think should be done? Should there be some sort of amendment to ensure that judgments in the mold or of the Supreme Court judgment should also be, perhaps, do we amend again to see that those cases, for instance, the ones for the houses of assembly and state assembly and national assembly, also get to the Supreme Court?
Yes, you know, I agree with you that in those matters where the Court of Appeal happen to be the final court, the parties that lost unjustly is a tragedy. But you see, by the time you open up these matters to go to Supreme Court, then the Supreme Court will not be doing any other matter, any other civil matter or criminal matters. The system will be hamstrung. So it is still not open for these matters to get to Supreme Court the way they are now.
Because, I mean, if the CG... Pardon me, go ahead, please.
Sorry?
No, go ahead. I thought you wanted to complete your thought.
Yes, I was trying to say that the final thing now is to strengthen the judicial institution so that even the courts at the customary court level, up to the Court of Appeal, should do justice according to law.
All right, Mr. Okezie-Okafor, Senior Advocate of Nigeria, thank you for talking to us today.
Thank you so much.
All right, and we'll be back in a moment to have another perspective on the same matter. Don't go away.